Have you ever heard this question from a bank or lender? The personal guarantor has already sold his property. Can we still recover our money? Most people think if the assets are gone, recovery is over. But Indian insolvency law says something very different. Let us understand this in a simple terms. This presentation is brought to you by Synergy Business Advisory Group Noida, a multi-disciplinary professional service firm delivering end-to-end advisory solutions across businesses, startup and growth advisory, CFO and financial management services, insolvency and restructuring, PMLA and PROFE advisory, and real estate consulting as well. Let us now begin today's presentation. What is personal guarantee? A personal guarantee is not just a formality. It is a serious legal promise made by a promoter or director in their personal capacity. When a company takes a loan and the promoter signs a personal guarantee, it means if the company fails to repay, the guarantor must pay from personal assets. This liability does not disappear just because the company goes into insolvency. Under the Insolvency and Bankruptcy Code, the liability of a personal guarantor is coextensive, independent. This means insolvency of the company does not protect the guarantor. Resolution or liquidation of a company does not automatically release the guarantor. Creditor can separately proceed against the guarantor. Many guarantors believe they can escape liability by selling property, transferring assets to relatives, or restructuring personal holdings. And they do this before any recovery notice, insolvency proceedings starts. They assume now the assets are gone, creditors cannot touch me. But the law does not support this thinking. Indian law looks at intent, not just timing. You see, under Section 53 of the Transfer of Property Act, if a property is transferred to defeat or delay creditors, the transfer becomes voidable at the option of the creditor. This means the transaction is not automatically valid. Creditors can go to the court. However, the law is fair for genuine sales where proper value is derived, good faith transactions are protected. The target is sham and collusive transfers, not real business deals. This legal position was clearly settled by the NCLT, State Bank of India versus Anil Dhirubhai Ambani 2020 case. The tribunal held that insolvency proceedings against personal guarantors are fully maintainable. NCLT can examine assets transferred done before insolvency. Selling assets before notice does not block recovery if intent is doubtful. This judgment sends a clear message: you cannot escape liability by selling assets in advance. Why this is important for creditors, for bankers, for financial institutions? It ensures that the recovery rights remain intact. Pre-insolvency conduct can be examined. Asset stripping can be challenged. Insolvency becomes a structured recovery tool. The law looks at substance over form. At Synergy Business Advisory Group, we assist in advising on insolvency proceedings against personal guarantors, tracing assets transfer done before proceedings, identifying suspicious or fraudulent transactions, coordinating legal and recovery strategies. Our goal is simple: ensure asset sale do not defeat creditors' recovery. This is CA and IP Praveen Agrawal signing off. Looking forward to seeing you all in the next video. Thank you.